Due to the fact that Judge Torres made the right conclusion, XRP may not file an appeal. Even if the lawsuit against Ripple XRP has not yet been filed, it has been given new dimensions as a result of the decision made by the United States Securities and Exchange Commission to stop the investigation into Ethereum. This decision has given the case new dimensions. The XRP army is currently waiting for Judge Torres to make a decision regarding fines and the final finding in the remedies phase. This decision is expected to pertain to the penalties. Furthermore, the Securities and Exchange Commission is on the fence about whether or not it would appeal the summary ruling that Judge Torres issued, which states that XRP is not a security in and of itself. The SEC element will not be filing an appeal against Judge Torres' summary ruling, according to attorneys and former officials of the Securities and Exchange Commission (SEC). It is possible that doing so will make the arguments that the SEC is making before the Second Circuit Court of Appeals less convincing. Please give it a big thumbs up, hit the subscribe button, turn on notifications, and feel free to join our community before we begin. This will provide you with all the information you require regarding XRP. It is quite unlikely that the Securities and Exchange Commission will file an appeal in response to the move that was taken by the SEC to end the investigation into Ethereum. This is the case regardless of whether or not a lawsuit is currently being filed between Ripple and the SEC. The matter involving XRP was once again the focus of attention from the general public. In spite of the fact that they were not compelled to do so, the Securities and Exchange Commission made an effort to send a letter to consensus for their consideration. According to statements made by Christina Oman, who formerly served as the Chief of Crypto Enforcement for the Securities and Exchange Commission, it is possible that the United States Securities and Exchange Commission will not file an appeal against the decision that Judge Torres has made regarding XRP. This is because the decision was made by Judge Torres. This is due to the fact that the Securities and Exchange Commission does not want to take the chance of bringing the Ripple opinion to the circuit level. However, it is possible that it will opt to simply allow it to remain there as an opinion from the district court. It has been established in a ruling that was given down by the Second Circuit Court that the tokens that were described in the lawsuit that was brought against Coinbase do not fit the criterion for securities when they are exchanged on the secondary market. Attorney James Murphy, also known as Metal Woman, is of the opinion that this is the case. Additionally, he added that Judge Torres was right on XRP, at which point he pointed out that the SEC might not appeal the summary finding on the inconsistent treatment of digital assets by the Securities and Exchange Commission is becoming increasingly obvious, as Murphy pointed out. Noting the SEC's contradictory remarks in the Coinbase hearing in comparison to its position on Ethereum Clio to Ripple regarding the unpredictable position of the SEC regarding cryptocurrency Clio to Ripple, Torres brought to light several fundamental issues that were present in the decision that the agency had created. These issues were brought to light in his re-enlightenment of this verdict, the position that the Securities and Exchange Commission has adopted regarding Ethereum transactions and the services that are related with them, such as staking and metal masks, is being called into question. Concerns and mistrust have been voiced as a consequence of the decision that was made by the SAC, particularly for those who are a part of the XPR community. Participants in the cryptocurrency market are wondering about whether or not the fact that Ether has been recognized as a commodity means that any decision proof-of-stake cryptocurrencies, such as Solana, Cardano, and Polygon, are now considered commodities. This is because Ether has been designated as a commodity. The regulator has not provided any clarity regarding the manner in which particular digital assets are designated as securities, which is the reason for this situation. An increasing number of investors are taking positions and wagering on the process of a price rise for the cryptocurrency for those who are bullish on XRP. This is indicated by the fact that there has been a considerable growth in the amount of open interest in XRP, which suggests that the number of investors participating in this activity has increased. In spite of the fact that some are not, it is inferred that the principles governing regulation are inconsistent. It has been reported by CryptoQuant that there has been a substantial rise in the amount of open interest in XRP. This pattern is advantageous because in general, an increase in the number of buy orders leads to an upward trend in the price of the asset. This pattern is considered to be advantageous. This position may have been bolstered as a result of a recent court order that may have supplied a clear interpretation of the legal standing of XRP cryptocurrency. This order may have done so by providing a clear interpretation of the position. The most recent developments in the SEC case against Ripple, which accuses the sale of securities that have not been fully registered, seem to have bolstered investor confidence, which appears to have been bolstered by the trend in pricing. The SEC complaint charges Ripple with selling securities that have not been adequately registered. On the other hand, quantitative techniques are designed to serve the purpose of warning investors about the likelihood of unpredictable market volatility. In spite of the fact that an increase in open interest is a sign of a higher level of market activity, it also brings with it the possibility of an increase in volatility. It is possible to compare a market that has a high open interest to a busy intersection. This is because additional activity brings about better opportunities, but it also brings about increased susceptibility to sudden changes. This is due to the fact that the release of new information or swings in market sentiment can prompt investors to quickly adjust their positions. Therefore, investors need to exercise caution. The market for Bitcoin is notoriously unpredictable due to the inherent unpredictability that it carries, as well as the decision that the Supreme Court of the United States will make. Disputes regarding interpretation are not yet known. The value of XRP is expected to increase by 21% on July 19, 2024, when it is predicted to reach a value of 6,002 cents. This is the day that is likely to occur. Although this is the case, estimations indicate that the general market sentiment continues to be pessimistic, which is why traders are exercising caution in their trading. At the moment, the Fear and Greed Index is exhibiting a grading behavior of 64, which indicates that there is a state of greed. This indicates that market conditions are favorable and that there is a strong predisposition toward purchasing. In spite of the fact that some attention is necessary over the course of the previous 30 days, there were 14 days in which the value of X or P increased, which accounts for 47% of the total period. It may be deduced from this that the degree of enthusiasm is rather low over the entirety of this time period. Since the Securities and Exchange Commission recently decided to dismiss all charges against Ethereum, the price volatility has exhibited a relatively reasonable level, coming in at $37. This is the average for cryptocurrency H since the decision was made. The spotlight has shifted to the ongoing lawsuit between Ripple and the Securities and Exchange Commission, which has been condemned by. Despite the criticism, XRP, which is currently trading at $4,998, has enjoyed a tiny uptick of around 1 today thanks to the lawsuit. The price has been oscillating in a manner that has caused it to go from a low of $4,906 to a high of $52 to a high of $52 throughout the course of the past 24 hours. On the other side, the volume of trading has reduced by 25, which may be an indication that traders are losing interest in the market. It is of the utmost importance to keep a close eye on the levels of support and resistance, which are 4,623.50 and 4,623.50 and 4,623.50 respectively. Investigations are currently being conducted into the decision that was reached by the SEC. There is little possibility that the United States Securities and Exchange Commission will file an appeal against Judge Torres' finding that XRP does not qualify as a security. Christina Littman, who had previously served as the Chief of Crypto Enforcement for the Securities and Exchange Commission, drew attention to the potential risks associated with an appeal, which has the potential to harm the position of the United States Securities and Exchange Commission in higher courts. One further thing that James Murphy had a problem with was the inconsistent approach that the Securities and Exchange Commission takes with regard to digital assets. The Chief Legal Officer of Ripple, who is frequently referred to as the Metal Lawman, has made the statement regarding the matter. The Chief Legal Officer of Ripple, Stuart Alderati, has voiced his disdain of the Securities and Exchange Commission (SEC) regarding the lack of regulatory monitoring that the SEC has now offered. Clarity, particularly in light of the decision to terminate the investigation into Ethereum cryptnados, is left wondering whether Solana Cardano and the Polygon will also be subject to unanticipated classifications as a result of this anomaly, which raises doubts about the classification of digital assets by the SEC. This doubt is raised because the anomaly raises questions about the classification of digital assets.